Go ahead and get started. I'm Kay Whitaker, and on behalf of the Lawyers Association Board, I welcome you here today. Also, we're very pleased to be co-sponsoring this event with Federalist Society, so welcome to the Federalist Society members who are here as well. I wanted to tell you I had a dream early this morning that I was making a presentation to a big auditorium full of people, and it was a big presentation. I had a big notebook full of notes, and I had locked it in my school locker, and I couldn't get to my notes, and my glasses were lost. So unfortunately, that's not the case here. Unfortunately for you, I'm not one of your presenters today. Our format here today is going to be somewhat debate-like. We're going to start with a 15 to 20 minute presentation on either side of the issue, followed by about a 5-minute response by either side, and then we should have some time at the end for questions. On an administrative note, this program is approved for 1 hour of Missouri CLE credit, but unfortunately Kansas has denied credit to this program. They are very persnickety, as some of you know, about what they give credit for, and if it's not something you can take back to your office and use on the particular brief or acquisition that you're working on right now, you don't get credit. I also wanted to mention that we're recording this program today. I think it's going to be available later on the Federalist Society website, and I think the discs would be available to anyone interested in for CLE credit for anyone who couldn't make it here today. And Kent asked me to make one plug for the LAKC YLS Skippy and Skitty's Drive, which is going on right now, and we ask you to donate peanut butter and children's underwear and gravy too through your firm's collection locations. It ends this Friday. Now let me introduce our two presenters today. First, a huge thank you to David Bill, the current Missouri nonpartisan court plan. David is a partner and chair of the management committee at Berkowitz, Oliver, Williams, Shaw, and Eisenbrandt. He has been practicing law in Kansas City since 1977. His practice focuses on complex commercial litigation and class action defense. David is one of 3 trustees, along with Chip Robertson and Ed Dowd, of Citizens for Missouri Courts, that was founded to focus on public awareness of the judiciary and to defend the judiciary against unfair attacks. He has also signed on to Missourians for Fair and Impartial Courts, a 501c4 organization formed to respond to legislative attacks on the judiciary and to the nonpartisan plan. He's also a past recipient of the LAKC Whitaker Award. Presenting an alternative approach to the current Missouri nonpartisan plan is Bill Placke. Bill is originally from St. Louis and is currently in-house counsel with a Fortune 500 company there, where his practice focuses on negotiating contracts and strategic partnerships. From 1997 to 2004, Bill lived in Europe and worked for United Pan Europe Communications, another Fortune 500 company, as head of their mergers and acquisitions department. He also worked for Clifford Chance, the largest law firm in the world, where he specialized in cross-border mergers and acquisitions. During his time in Europe, he was a repeat guest lecturer at St. Edmund's Hall, Oxford University, and at Wolfson College, Oxford University. We are very fortunate and grateful to have 2 such distinguished guest presenters with us today to inform you about the current judicial selection process in Missouri and why it should or should not be replaced. And with that, I think David Oliver is going to start with his presentation. Thank you.
Thank you, Kay. I also had a similar dream that Kay, I also had no clothes on. Chip Robinson and I have become good friends. I've always had a great deal of respect for him, both as a lawyer and as a judge of the Missouri Supreme Court when he served on the court. He called me last week. In case you don't know this is a plea for some sympathy. He called me last week to say he was going to give a talk to the LAKC about the Missouri plan. Would I agree to do that? Because I like and trust him, I said yes. And then he said, Kay Whitaker will call you. She called me and then sent me the email invitation, and I realized this was a much more elaborate thing than I necessarily thought it would be, complete with PowerPoint. I have no PowerPoint. But I do have some things to say. These are my opinions. These are not Chip's opinions. If Chip had given this, and he did send me his PowerPoint presentation, which is, those of you who know Chip, it is a remarkable experience to receive information from him. But no way could I use that PowerPoint. There were airplanes, there was a picture of a cathedral in Europe, and there was also the Chief Justice of the Supreme Court of Uganda. So I am not going to do that. But I am going to say something because I think this dialogue is actually very healthy. I think the more people know about how Missouri selects its judges, the better. We know an awful lot about how we elect our governor and how we elect our legislature, and I think there are many people, I think lawyers tend to know a bit more about it, but I certainly know all my friends who are non-lawyers who, when they get in the voting booth and are confronted in Jackson County with a long list of judges, most of them stand there and go, who are these people and what have they done for me? In all honesty, I don't think that's necessarily a bad thing, but I'll come back to that. This is a very energizing event for me because I don't mean to get too high on a horse, but some of the things I am going to say probably would get me thrown in jail in Pakistan. And I say that with some humor, but also with some seriousness. One of the things I wanted to do was bring to you and pass out General Musharraf's decree suspending the Supreme Court of Pakistan, placing the justices under house arrest and replacing them with justices which he believes are more amenable to the way in which he would run the democracy of Pakistan. The president of Pakistan rails against activist judges. He does not define what activist judges are, but he uses that as a basis to suspend all of the civil liberties that the people of Pakistan should enjoy. I doubt that is something that would happen in this country. I think that would be a rather dramatic event. We have a longer democracy or republic, and this argument that we're talking about today has gone on for quite some time. But I have to be honest with you, it is a very important decision, a very important discussion that we're having. I want to give you a little personal background so you understand this. I am a fourth-generation Missouri lawyer on my father's side and a third-generation Missouri lawyer on my mother's side. So it's either in my DNA or I am severely in a rut. I have practiced law for 30 years. I practice in front of our courts. I have appeared before the Missouri Supreme Court. I have appeared before two of the appellate district courts. I have appeared in quite a few of our circuit courts. I realize that I have practiced law for 30 of perhaps the 67, 68 years in which the Missouri Plan has been in effect. And I am here to tell you I have never appeared in front of an activist judge or an activist court. I have appeared in front of judges who take an oath to the Missouri Constitution and understand what that is, and I think try very hard to perform their duties as judicial officers of this state. I happen to believe that it is very important to protect the third co-equal branch of our government. I also think the system that was put in our Missouri Constitution and has been tweaked since 1940 does an awfully good job of giving us good judges who know what their job is. My father was a federal judge. He was appointed by President Kennedy. I'm sure there are people in this room who would think he was an activist judge. I don't happen to agree with that, but I'm sure they do. I am very interested in the policy of our state government. I have to confess to you, I am not, while I vote, I'm very disappointed with our political process. I think there's way too much money in the system. I think it's obscene the amount of money that the executive branch or those who want to serve in the executive branch have to raise. I think it's obscene the amount of money that those who want to serve in the legislature have to raise. I am a strong proponent of separation of church and state. I'm also a strong proponent of the separation of the judiciary from politics. I happen to think both are under attack. And that's okay, because that's what's happened in our country, both at the federal level and the state level, since this country and this state were founded. John Adams tried to pack the court as he left office, and Thomas Jefferson took over and the country survived. FDR tried to pack the court and was unsuccessful, and the country survived. So I want to put this in a broad perspective, because maybe 15 years ago, the left was attacking the Missouri Supreme Court and wanted to change the way in which judges were put on the bench. And now the attack comes from a different source. I do think, and I want to make some political, some policy, and some practical comments. Again, I'll be personal. I do not contribute to political campaigns as a rule, but some of that is just my own principle, belief that there's too much money in the system. I did give some money to Matt Bartle when he was a law partner of mine because he's my friend. Unfortunately, I disagree with Matt Bartle on almost every social policy subject. And because my name is in his data bank, I have had to explain that I gave him some money as a friend, not because I believed in his positions. I guess that's also a way of saying I do think it's very important for lawyers to serve in the legislature. Because I happen to think that the quality of the legislation also has an impact on the quality of what judges have to do to interpret that legislation. And the sloppier and more complex and more convoluted the legislation is coming out of the legislature, the more difficult it is for the judiciary to interpret that legislation. I'm going to make some political comments first, but I want to preface that by saying that I think this is a subject that should be treated with civility and an open mind and flexibility, because this is a co-equal branch of our government. Judges, we all took an oath as lawyers to defend the court system, and I take that obligation very seriously. So last summer, when I had been out in Colorado for about 3 weeks and came back to Kansas City, picked up the paper and saw the correspondence, the reports on the correspondence that was going on between the governor's chief of staff and the Judicial Commission, I thought, well, here it goes. And it was as much the tenor of the conversation that disturbed me as anything else. There is nothing wrong with trying to come up with a better way to put judges on the bench. Nothing wrong with that. And that's a discussion that is going to take place in front of the legislature, I believe. And I will tell you what I'm prepared to do as a lawyer and as a citizen of this state in that exercise. But what we were faced with last summer, and again, folks, I would say this, to be clear, I would say this no matter who was the governor of this state, Democrat, Republican, Socialist, Communist, you name it. I would say this no matter what. So in that respect, my comments are not partisan. But I understand that politics is hardball, and unfortunately in this state and in this country at the moment, the partisan politics discussion is toxic. It is not a good discussion. How many of you honestly believe that the political discussion of what's going on in this country today is an elevating, good discussion? And so what I saw happen was that the Judicial Commission, which understood what its job was being subjected to a political attack. Now they got through it. Judge Breckenridge was eventually selected by the governor, and she is actually being sworn in today. That's the conflict that Chip prevents him from being here today. He wanted to be down there to swear her in. She will be up for retention election a year from now. That's the way the system works. I am assuming that this group has a general understanding of what the Judicial Commission is all about, how it works, and how it has worked for the past 67 years. If you don't, I'm going to give you my email address, and I'm happy to send you the speech that the Chief Justice gave to the Senate explaining what the Judicial Commission does. I will also direct you to those parts of the Missouri Constitution that set it out. Some policy discussions. As I said, the system works, and it has worked for a long time. I, in practicing law in front of our courts, may disagree with some of the decisions that are rendered by the Court of Appeals and by our Supreme Court. And I understand as a lawyer for one of the clients what I need to do to try to persuade those decision makers that I'm right and the other side's wrong. Sometimes I win, sometimes I lose. I think what's going on today is that there are groups that are disappointed with the way in which judges are ruling, and so they decide rather than to challenge that evolution of the law, if you will, they will increase the ability of the executive and the legislature to control the decisions of the judiciary by having a firmer hand in how the judiciary is selected. And I think constitutionally, that's not the way Missouri decided to have it done. There is a dilution between politics and the judiciary and the selection process. For those of you who haven't read this book, Truman by David McCullough, I would encourage you to read it because it talks about Tom Pendergast. It talks about the problems that caused the state of Missouri, through its Constitution, to correct some of the problems in the judiciary. So the Missouri Plan really was born out of a lot of problems that had occurred in the 30s and early 40s as far as the administration of justice. Someone grab me and tell me when my time's up. In this state. Now that's not to say that we have bossism in this state today, the way we had Boss Pendergast. But I do believe that it is very important to keep a system which has lots of checks and balances, lots of diffuse ways in which a judge gets recommended to the governor to select. I know a lot of the lawyers and actually some of the non-lawyers who have served on the commission. I know some of their politics. They lay their politics, either Democrat or Republican, they lay those politics to one side when they perform their job as a commissioner. They understand that. It's the same that a judge does. A lot of judges are very political in their life before they get on the bench, but then they understand they need to put that aside. And that's what goes on with the commission. And I've talked to people who are on the commission now, people who are on the commission in the past. These are all lawyers I know. These are all lawyers I respect. They try to do a good job. A practical concern, and I practice law. I had a very major lawsuit in the state of Texas. Texas elects its judges. There's a lot of money in that system as far as electing those judges. The quality of the judicial decision-making out of that state was not improved by the election and amount of money that you had to pay those judges. I had to take a Kansas City client. I had to hire the former Chief Justice of the state of Texas as co-counsel because he knew how to work the system politically. It's a Chief Justice who finally said, enough's enough, there's too much money in this system, it's not good. But Texas still does that. Now this state has a very mixed system. We ought to be proud of the fact that the Missouri plan that was put into place has served as a model for a lot of other states in how they select judges. We also have the situation of outstate where judges are elected. In the past, that has been, by and large, a non-event. And it's worked, it's kind of worked. I think the politics and the partisanship that now is being injected into the judicial branch of our government is causing that election not to work. The way in which Judge Brown was removed from office in Cole County, in my opinion, was swift voting. Pure and simple. And I don't think we should be proud, any of us, that that's the way in which something happened in a county that doesn't have the nonpartisan plan. Now I'll make a final practical comment. And this is more from the business side as opposed to the lawyer side, because I spend a lot of my civic life dealing with the business community. They are very tired of the amount of money that they feel forced to have to give to political campaigns. But they do it. I talked to a businessman this morning who wrote 20 checks yesterday to various people running for the legislature. He doesn't know why he does it. He doesn't understand what it gets him, but he does it like Pavlov's dog. And he said to me, if I have to do this for the judicial system, I'm not going to like it. So that's a practical consideration. Now I'm going to stop. I'm going to come back and tell you later about Missourians for Fair and Impartial Courts and the Citizens for Missouri Courts. I do want to say, I have to say this because I believe this profoundly. Bill Placke, I have never met the gentleman. I am so glad he's here. I think we need these types of discussions. I don't want it to be partisan. I want it to be policy. I do think there is a strategy here that is political. I don't think that the Federalist Society is really pushing that. I actually spend a lot of my life trying to kill class actions in lawsuits, and the Federalist Society has informed me greatly in the research that they do. So if this is a policy discussion, it's wonderful. It's the politics that really disturb me. Thanks.
Thank you very much. I hope you can see the presentation. Many of you can. I'm going to be referring to it quite often, but we'll deal, and I will provide you also with my email address if you want any of the supporting materials. I'm happy to provide it. I think one thing we should certainly get, well, first, all opinions here are my own. They're not those of the Federalist Society. They're not those of my employers, current or past. But this is truly, I hope, a good policy discussion. And the brief chat I've had with folks that are sitting here with at the table, indeed, I want to stress that this is a good and proper discussion we should have often. How are the persons who serve in the third co-equal branch of government appointed to that office? And hopefully some of the ideas that I leave you with today will give you some further thought. I too think that there are a number of areas actually with which we agree. And I'll start out first with is I do not, and I would strongly oppose any system where our Supreme Court or appellate court judges are elected. There is a poison that's in Illinois, there's a poison that's in Texas that causes people to have to raise millions of dollars to get put on the state's highest court. How can that not be a corruption, or at least the appearance of a corruption of justice when a litigant who, as an attorney who perhaps is just starting out, maybe it's becoming a counsel lawyer, appearing before the Supreme Court, lots of money over the years for that judge to get there. Regardless of whether or not that particular judge would be influenced, it gives the appearance of impropriety. And we as lawyers know that appearance is often, there's going to be a loser, and someone will be letting their hat and say, look, it's corrupted. So just as a starting point, if anyone is looking for a system where judges are elected, count me out. So I fully support Missouri's current, what I call broken Missouri. It is a truism that people forget the words you say as time goes on, but the impressions linger. So hopefully there are two impressions that you leave with today. First of all, I think, and I believe that the current system for appointing judges in Missouri state courts is in need of reform by updating the current model, which in twofold eliminates a lot of the secrecy in the current process, and second, brings more public accountability into the process. Indeed, we are trying to balance twin but opposing goals. You need independence in the judiciary so they can make the unpopular decisions when the majority wants to pressure down. But at the same time, you need some level of accountability. A 2002 study by the American Bar Association itself says that the most critical time of a check by the legislature on the judiciary is at the time of appointment. Secondly is that I don't believe that it does any good whether it's the Adam Smith Society or someone else out there creating a political debate out of this. I do agree that things went too far this time. I found that quite unfortunate because I don't think it helped the process. It didn't help the discussion. It should be healthy and lively debate. What are the alternatives? Why would we want to change? And hopefully I'll bring some of those out here today. But the second hand of that is I don't believe it's helpful for especially influential members of the civic community or former judges of the Supreme Court to come out and say all efforts of reform are wrong without at least looking at the alternatives first before taking that decision. At least their time on the bench and said, listen, even if you think you know what the right answer is, listen to both sides first, then at least come to your decision. I don't believe there's been proper deliberation. Unfortunately for the debate, that means if people are going to change their minds, they're going to have to do some type of step back. In my experience, that comes only at the last end of part stream. As soon as we get the first slide up here, I'm going to start with some words by Chief Justice Welfare. As many of you know, he passed away a couple weeks ago, but we found a speech that he did in 1985 to the Senate committee looking at the Missouri plan following an appointment by a governor which was seen by many as a corruption in the process. And he made three statements, I think, that really sum up, in my opinion, some of the things that we're talking about. And we're going to come into focus here in a second. And I would paraphrase him, and you'll be able to see it for a second. As soon as you get time to get to the second one. The first one is, he summed up his statements to the Judiciary Committee. He was calling for reform to not be selecting their successors or their colleagues, and lawyers should not be choosing their judges. That, I think, was a pretty profound statement at the time. The second one, and one which I think more in sharp would be when persons like me trying to change the embedded system to be thrown in jail, is he said to the Senate Judiciary Committee, unfortunately, I don't think you're going to get much help from people in my profession because they are entrenched in the system. They're the ones in power. The ones in power don't naturally give up control. So you're not going to get any help from the legal system. I hope that something has changed in 22 years. And I think most profoundly was the second statement of the legal secretary. As he said, listen, so many of the people in support of the current plan say, well, judges know best, and lawyers know best what makes a good judge. And he reminded us that courts belong to the people, not to the judges. We often hear judges, lawyers say, in my court, in this court, and I understand they're trying to control the court, but at the end of the day, it is the people's court. It is the court of the citizens, where we're privileged to practice on occasion. And in my case, since I'm a corporate lawyer, if I'm ever in court, it's usually a very bad thing. So, with that said, I think Justice Mulder makes a terrific observation. Okay, so the next slide would be what I call the 5 myths of the Missouri plan. I'm going to kind of walk around here so I can hit the button once in a while. I'll feel rather like back at St. Edmund's Hall. Get some focus. It's nothing with the iced tea, it's actually blurry on the screen. The 5 myths I'm going to go through is, first of all, that the process is not partisan. Of course it's partisan, at least in my view it's partisan. I'm going to set up some clear issues where that is. But the selections are based on merit, and this conundrum where people say that 30 states have adopted the Missouri plan, it's actually some form of the Missouri plan, and there are numerous forms of the Missouri plan, with Missouri's form being the least accountability. And some issues on the Sunshine Law, and not to be a complete, someone up here just poking holes, I'm going to try to present you what I think is a good alternative. So, I'm going to skip this. This is a really good slide. I hope they can get it.
It's on the line.
So, on this slide, I think this slide is very, very telling. So, if you look at this side, this is the public input of the state judicial selection systems across the country. On the far left side, this isn't left, right, in the system we have of what's, who's on the left, who's on the right. It's just that this is an election. Now we agree that is the most public input into the selection. I'm not saying that we should go there. I actually think that's bad. But this is where you have Illinois over here, Alabama, Louisiana, Mexico, Texas, West Virginia, where you have these all-out dogfights based on partisan sides and the money gets in there. And again, I would never advocate that type of system. And then you have nonpartisan elections. You just remove the R&D, but all the bad things are said about the other candidate. And I also don't think that is a very good system. Now, this totals to about 27 states. So somewhere in here, then we have, okay, what is, if we move away from elections, then how's it appointed? Well, in South Carolina and Virginia, the legislature actually does the whole thing. That's it. You put up some candidates, the legislature votes on those judges, and they get put on. And then you have in California, Maine, Mass, New Jersey, Delaware, you have kind of a mix where you have a merit selection commission up front, followed by gubernatorial appointment, followed by legislative confirmation. And then here you have a legislature-appointed commission, which does a selection up front. The governor then nominates, and 3 of these, 4 of these, all of those, get legislature approval. And as you get further down into the least amount of public input over here, you have, for instance, in Florida, where the governor approves the commission, and there's no legislative confirmation, but the commission selects one judge, and the governor chooses from there. And then in Missouri and Kansas, as you see on the far side, together with Wyoming, Nebraska, Iowa, Indiana, and Alaska, have the least amount of public input into the selection system. And when we say public input, what does that mean? Well, who's on the commission? How do they get there, and who influences? I'm not going to rehash Missouri's. I think most people know that there are 3 members that are elected by lawyers statewide, and 3 members appointed by a past or current governor and the Chief Justice of the court for the Court of Appeals, and the Supreme Court is the Chief Justice of the Supreme Court, and then in the other districts is the Chief Judge of that court. So the next slide, if I could go to, the question is, well, what about that commission? Why is that commission so far? Thanks, Bill. So since 1995, there were 5 vacancies on the Missouri Supreme Court. 6. During the 12 years of Democrat governors, you had 5 vacancies on the court. The commission supposedly acting in a bipartisan fashion provided a Democrat governor with all 3 Democrats as nominees for the state's highest court. Not 1 time, not 2 times, but each and every of the 5 chances. So you list that out. You had the opportunity, a Democrat governor, to appoint someone to the Supreme Court of Missouri. 3 possible nominees, all three every time were Democrats. That means, take a coin, flip it heads or tails, and do that 15 times. Actually, you have to do it 19 times or 20 times in a row because you have a Democrat in the office of the control. And you had the odds are more than 1 billion to 1 that you could possibly do that. Roll forward to the summer, and I think this is where a lot of the acrimony came from over the summer, and take as a presumption that a governor of one party, doesn't matter if it's Missouri or California anywhere, governor of one party is not going to appoint someone from the opposite party unless forced to do so. Now let's look at what happened in Missouri. There was an excellent article done by Missouri lawyer over the summer that went and researched this. And they said, well, in the entire history of the Missouri plan, only 3 times had a governor of one party chosen a judge from the other party. One of which was Kit Bond, in his first term, was faced with 3 Democrats as his nominees, as the holdover from the Democrat Commission just gave him 3 nominees. And he had to, in their words, hold his nose and pick one. And whether that person ended up being the greatest or not, it's not there. So that was almost 35 years ago. The time before that was in the late 1940s, and when the plan first came into being. Now, I will agree, the Missouri plan was a massive improvement for its time. Absolutely. But then the question is it in need of tweaking? And again, I'll go back to that and say it is in need of tweaking, and hopefully came up with something good. So a lot of the hostility over the summer, and I do agree, I think it's helpful for people to say, shine a light on judicial activism. I think just looking at the process itself is, so you had a commission with a sitting governor, 2 Democrats and 1 Republican. In many people's minds, the commission made the choice of who was sitting on the bench, period. And if you look back over the last, since 1995, it would appear as though the commission broke what it normally is inference to make. So it would then seem to me to at least say, okay, well, what happened before that? And I think, and please don't mistake this or go through the presentation, look, this system has been gained by Democrats, it's been gained by Republicans, it can be gained, and it will be gained unless we do something to fix it. So if you can just move on to the next slide. The other thing before I go into, so Kansas system also, it arose out of a system where then resigned, the lieutenant governor took over, and 10 days before the inauguration of the new governor, the Republican lieutenant governor put the former governor on the Supreme Court. Nice and convenient. Folks in Kansas said, hey, enough is enough. The system can't be gained in this form signed in Missouri. In Missouri, of course, we know that it stemmed out of the Pendergrass and the Democrat city bosses in St. Louis controlling the systems, putting people who were their cronies rather than qualified persons. Again, 1940, great concept. It actually rose out of 1911, Albert Hale's concept of a merit selection system, and it has served well for a long period of time here in Missouri. there have been a number of abuses, or at least one prominent abuse by the Republicans when a governor, sitting the Republican governor's chief of staff, 33 years old, no judicial experience, I believe maybe as a municipal court judge for a short time, virtually no legal experience, was appointed to the bench. And at that time, Democrats were outraged. That's what Justice Weller's speech came out of, saying, hey, look, we've got to fix the system. The Missouri Bar formed a committee on trying to fix the system. And I suppose that all that went away after a time because people said, okay, well, it'll change. But surely that's enough evidence to show that there is a possibility of gaming the system. And you as lawyers, as stewards of the system, one of the questions you have to say is, should we get up and lead again and try to fix this? And what is the right fix? Maybe the plan that I'm floating is not the right fix. So let's bring it up. Let's get some ideas. Surely want to see thank you. So this is one that I'm going to show, and particularly probably poignant for those of you here in Kansas City. So again, this commission is supposed to select on merit, not based on two of the three nominees with one of the applicants who didn't make the final three. To make things equal, all three were the same gender. Two of the three were from the same party, 2 of the 3 were Democrats. And 2 of the 3 were of the same race. So we've taken gender and hopefully race, at least that inherited part here. And it strains, in my view, it strains credibility to argue that on paper, nominees 1 and 2 were more meritorious than applicant A on the bottom. It's probably hard for some of you to see over there, but let me just briefly go through it. So Supreme Court Judge, oh, sorry, I actually skipped over to the wrong slide. Can you slide it? Sorry. One more. Yeah, here it is, sorry. So nominee 1 of 3 at the lowest bar rate, 73% of any appellate or Supreme Court judge in the 2006 retention election. And this person was rated in the bottom 20% of all the judges in St. Louis in the 2006 retention election. Nominee 2, interestingly enough, called for the reform of Missouri's form of the Missouri plan, and seemed to concur with 161 possible chances to chair the commission while serving together on the Court of Appeals. Now let's compare applicant A, who did not make the final 3. Top of the undergrad journalism class at Mizzou, very well-known journalism class, Harvard Law School grad, partner in a major Kansas City law firm, more trial and appellate court experience than nominee 1, who made the panel, and same gender and race as nominee 1. Now remember, nominee 1 had received the lowest retention rating, bar rating, sorry, the retention election, than any appellate court or Supreme Court judge. What this says to me is that nominee 1 was put on that panel, not for merit reasons, but for considerations other than merit. Now, what can that be? Political reasons. People want to talk honestly about it and truthfully about it. Nominee 1 was put on for political reasons alone. And in fact, I have it from one of the people that was interviewed by the commission that indeed there were very overt political statements made in these interviews about someone's chances because they were, quote unquote, too close to the governor for consideration. Now, being too close to the governor, I would say, is another political factor. So politics is part of these elections, or part of these considerations. One of the earlier slides also went through, and I'm sorry, I don't want to bore you to death, but again, I have these. You have a current sitting 3 of the last appointments to the court prior to this appointment. One was a chief counsel to a sitting governor appointed by a succeeding governor. He ran twice for attorney general statewide. It's a political office where you have to raise a lot of money to run. He had no judicial experience, very bright person, no doubt about that, but no judicial experience, and was considered the best person in the state. Surely there were political reasons that that person made the final panel. Now, Young was a person who 3 years prior to being appointed to the bench had given $30,000 to Democrat runners and Democrat candidates. $30,000 is not a lot to some people, but it's certainly not an insignificant amount. It will get you an appointment somewhere with the highest person at the state when you want. So it just seems to me to strain all bounds of credibility to say that politics does not play a role in the selection of judges. Is there a plan where politics plays no part? I don't think so. But one way you control politics is by shedding light on it. One of the defects, I think, serious defects in Missouri's plan is the lack of public access to the process and access to the press. And hopefully the new plan will correct some of that. At the same time, you want to promote the commission having free and full debate amongst the members themselves. So the next thing I'm going to hit on the slide is, here we go. The fact that 27 states have some form of the Missouri plan. And I got to focus on this thing, some form of. Because going back to that early slide, you can see that the Missouri's form of the Missouri plan is the extreme. 7 states have very little public input. And then as you go towards the center, you'll see, and if you look at the research, the American Judicature Society has a fantastic website devoted to this. Just click on the states around. You'll see that the modern trend is for legislative confirmation on the tail end. Now, I understand the biggest criticism of this, and I hear it, that, well, look what happens at a federal level when it comes to federal judicial appointments. I would say in the state of Missouri, you have less of a problem on that. And I think when the founders created this system, they probably didn't envision a country of 300 million people. Perhaps they did. But in that small, in a state like Missouri, if you have a guy like Senator Barber on the commission who's vetting people, and he's going out to bork someone, or if he's listening to special interests, I have a stronger feeling that he will listen to me in St. Louis calling him up going, come on, this person, you're treating them badly, whatever. Then Joe Biden could care less if I called him up and says, you don't vote for me, you don't care, you don't care influence here, I don't talk to you. In a smaller state, or in a smaller state-sized system, your ability, I believe, to control the special interest groups and people getting borked, if you will, is going to be much better than at a federal level. If we can go, so the majority of the states, so again, you get some form of, and I would encourage you to look at the scholarship, there's plenty of plans out there. The plan I'm proposing is very much along New York and Delaware model, which is considered a Missouri plan. The Missouri plan is just that you have a commission up front, as far as I can tell from the American Judicature Society. I asked them for clarification, but when you pull these numbers together, that's where they get, and we never can kind of get beyond how do you get, if there's 27 states that have partisan and nonpartisan elections, how do 30 plus states have a form of the Missouri plan? I mean, the numbers just don't add up unless partisan elections are also considered a Missouri plan. I don't think so, and hopefully no one will want to go into one of the things is in Missouri's form of the Missouri plan, again, you can judge for yourself whether or not you think it's part of the extreme, but I would encourage you to take a look at the model American Judicature Societies. The model schematic is a lot of what the new proposal follows, right? And then you pull different things. One of the things that they point out, which I think also emphasizes how extreme Missouri's plan is, says that if you have a judge on the panel, you need to minimize that judge's role because the judge will disproportionately influence that commission. In Missouri, the judge is not only not minimized, the judge is the chair. The whole commission is run out off the judge's fax machine out of that judge's office. Again, I'll go back to Justice Welder. Judges should not be appointing their colleagues or their successors. It's just something not right in that type of a system. It's fine for a fraternity, but this is a third political branch of government. So let me just, I'll briefly review, because one of the questions is, do I have 2 minutes, 1 minute, am I over?
Well, we're getting there, so.
How polite. Not even skip but I'll bring you some. There are so many different commissions out there. I'll go really quick. I'm going to read this, so you're going to have to be patient. So in Delaware, there are 9 commissioners who serve at the pleasure of the governor, 4 lawyers, 4 non-lawyers, and the Delaware bar may nominate 1 member, but the governor can reject that member. Florida has 9 commissioners, 5 non-lawyers, plus 4 lawyers picked from a list of nominees submitted by the Florida bar to the governor. Each open position has 3 potential nominees by the governor. Now, this is for the commission. So the commission is being appointed by the governor from a list of people. And then the commission sends the governor name, and the governor may or may not reject. In New York, there are 12 commissioners. And it's a very interesting makeup. I believe it's in New York. That's where I practiced for quite a while. It never ceases to amaze me, the complexity that some of these things are put to. So in New York, 4 are appointed by the governor, with 2 non-lawyers and 2 lawyers. 4 are appointed by the Chief Justice of the highest court, with 2 lawyers and non-lawyers. The state Senate majority chair and the minority chair each have a representative, and the House majority and minority each have a representative. That to me is a very interesting mix, and at least sheds some light on the fact that, look, there are multiple ways to form a commission out here. Even if you don't want to have legislative confirmation on the back, consider the makeup of the commission. And is there a level of public accountability into that commission? At least in New York, you have Senate majority, Senate minority, and also the governor's picks, and they serve at the pleasure of that one person. I will take 1 minute to briefly overview the proposed plan. The proposed plan, I'm going to skip over the sunshine stuff, get some rules. But basically, the proposed plan sets out a 10-person bipartisan commission. And in my view, a bipartisan commission is very important. And I would urge you to listen and look at the research rather than some of the things that have been said about a bipartisan commission. 30-year study done by the American Judicial Society says that bipartisan commissions are 3 times better at minimizing political considerations when doing their work, as opposed to a Missouri-style plan. 3 times more likely to minimize. That's not just something I've made up. That's legitimate research and study. So when folks go out and say, hey, if you create a bipartisan, you're putting politics into the system, that's a nice soundbite, but it's not fact. At least not based on anything other than knee-jerk reaction. And again, I'm disappointed at those people that disregard what research has been done out there. And a couple of weeks ago, Virginia Young did a great article on the Missouri Ethics Commission, where she said, well, you know, talking with these people, maybe they weren't forthright, but at least take some support from that. It says, look, they leave politics outside, literally leave them outside the room because they're split equally on the Ethics Commission. That they know if they bring politics into the room, someone's going to call them on it, and they say, get it. So that's why I'm saying I think a bipartisan commission, supported also by the research, is the best way to keep politics out of the process. From that group takes a list of 5, gives it to the governor. 5, according to the American Judicial Society's research, is the quote-unquote ideal number to forward over to the governor. In an earlier plan, there was an ability for the governor to ask for a new list of 5. I received a lot of comment on it. Thank you if any of you in the room did that, and we took that out. You know, that was a step too far to allow the governor to reject it. Then the next step is the governor selects one of those nominees, and then within 90 days, the Senate must give a mandatory up or down vote. If they're out of session, there's ways to call them back into session. There's some handcuff issues there, but hopefully the way the timing works, it would be done during special session, the way it all works. But it's a 90-day mandatory up or down vote. And if that's rejected, the process starts all over again. During that 90-day up or down vote, there's a role for the Missouri bar, similar to the ABA's previous role with federal appointments, where the Missouri bar can come up and list an applicant as qualified, exceptionally qualified, qualified, no opinion, or not qualified. Missouri bar weighs in. The Senate can push that down to a Judiciary Committee for review. They can call. There was a suggestion by one of our former U.S. senators here who've gone through a particularly rough process. He said you ought to allow the person being appointed to have their own counsel and processing anyone submitting evidence, and that ought to be under oath. I thought that was a fantastic suggestion, and that's been incorporated into the plan. So the makeup of the commission, then that's important. Governor has 4 appointees. fine, that's one more than he currently has, but or he or she would have, but as a percentage, it's actually a lower percentage of the commission than the governor currently has. So 2 lawyers, 2 non-lawyers, and then the next 4 are the Senate majority, Senate minority, House majority, House minority, and also the governor's appointments must be from both different parties as represented by the House. So you're going to have a balanced commission. And then the final 2 are from the Attorney General, also must appoint from the majority and the minority. And again, the idea is I like the idea that there's one step removed from direct accountability. These people do serve at the pleasure of the appointed person, but can only be replaced once a year, the second week of January, so you don't have anyone sliding in between election and pro, especially switches majority and minority. And then we haven't touched the retention election. I would recommend to you, though, that if the public has input through legislators at the appointed time, that you ought to consider lifetime appointments for judges. I would advocate that, but I understand that the people of Missouri Bar came out quite opposed to that last year. I don't want to open up that can of worms. We're not trying to take any voting away. We're trying to preserve independence. So that in sum is the new plan. Again, this might not be the greatest thing ever done. It's something I've put together, cobbled from different selection processes. I think it works. But we'd love to have input. We'd love to have the Missouri Bar engaged. We'd love to have everyone engaged in the subject. So thank you, and I apologize for this so long.
This is going to shock a lot of you in the room, but I'm going to be really brief. And I first used that he would take great offense at what you have said about him as the former Chief Justice of the Missouri Supreme Court, and he will probably say something about that. So I just would give you that fair warning, because he takes this very seriously. I also think any elected official, either running for governors, Secretary of State, Attorney General, or anybody in the legislature, if they got 73% of the vote of this state, they would be ecstatic. They would be ecstatic. And so I take the flip side of the appointment process, the retention, the judiciary in this state, both by polling and both by people who have re-elected our judges on a regular basis over the past 65 years, would confirm that the system is working. An observation, the only way we're going to change this, and Bill, I am more than willing to consider, just as a matter of policy and kind of interest, a new system. I do have to tell you, this to me is an even more complicated system that would take even longer to get a justice on the Supreme Court or judges on our appellate level. And I thought it was a tragedy that the governor took as long as he did to slow the process down to restore a co-equal branch of our government to full force. I think he did it. Again, I think you and I agree, keep politics out of it. I thought that the governor's, I am making a political comment here, I thought that the governor's attempt to screw up the system this past summer was reprehensible. I appreciate the fact that I think he has moved off of that. I think that when a governor has an opportunity to appoint somebody to the bench, they should accept the system and get it done as quickly as possible. If the governor believes that there's a better way to do it, the only way we're going to do this, and this is the practicality of it, folks, the only way we're going to do this, because it's in our Constitution, is eventually a vote of the people. It's going to have to wend its way through the legislature. I have no doubt that there will be a number of legislative proposals that get submitted to the legislature when it comes up in January. I plan to be down there as a citizen of this state and as a lawyer to say that I think the system works well, and I would be very reluctant to put the state through the time and expense involved of changing a system that I think works. I think the burden is on those who want to change the Constitution, and I don't think the Constitution should be changed lightly or easily or often, in all honesty, because it is a major thing that we do. For those of you that have been involved in initiative campaigns in this state, the amount of money that needs to be raised to pass an initiative in this state is obscene. I also have the belief that given the toxicity of the partisan debate now going on, that a discussion to amend Missouri's Constitution as to how it appoints its judges will not be a policy discussion, and that it will further draw our judiciary into attacks on them that they are activist judges and that they're not deciding things the way a distinct minority in our state thinks they should be deciding things. This is an appeal to all of you who I think are the great silent majority. There's huge irony in my making that statement because Richard Nixon used to minority. But the minority of this state thinks the system is not broken. And we don't need to put the state through this. That's why I've signed up for Missourians for Fair and Impartial Courts. It is a broad-based coalition across the state. If you Google Missourians for Fair and Impartial Courts, it will come up, you will see it. I would urge you to join it as well. I am also one of 3 trustees. I've never been a trustee of a political action committee before in my life. But I am proud to stand up for the judiciary, to be part of a political action committee that is going to educate the public about how the system works, because I have no doubt that this is going to become an issue. It will also protect those judges who do run for office from unfair attacks, which is what I think Judge Brown experienced in Cole County. I think it was a stealth attack at the last moment that we've seen it happen in the other branches of government, and I want to do everything I can as a citizen to prevent that happening to the judicial branch of our system of government. My email address is doliver@bowse-law.com. I will send you any of the information. Again, the Chief Justice's talk before the Senate, in which she explained how the commission worked. I find it ironic that she needs to be hauled before the Senate to explain what everybody ought to know, but she was. She's a very polite person. I disagree with you, Bill. I do not think that this particular Chief Justice exerts a huge amount of political force in the way the commission operates. This is one of the most gentle, polite people in the world. And so I think you overestimate the infection of politics that it plays in the commission. I always voted for Jack Danforth when he ran for Senate, and I'm a Democrat. And I do believe devoutly in God, and I will say this, that I think lawyers, when they understand how judges get elected, put their partisan politics aside. And the slide you showed that there were Democrats, there were Republicans, I think those commissioners tried very hard to be as apolitical as possible. That does not mean it's completely out of the system. It will never be completely out of the system. But it is a diluted system that provides the judiciary with independence. Thank you.
And again, I think if you focus on, maybe I'm too driven, to analyze and look back. Okay, so I put it in the PowerPoint up here, it's available. You can email me. My email is bplacked, @charter.net. I'm happy to send everything over to you. But the fact of the matter is, you can't attribute anything but politics to the fact that over a 12-year period with 5 possible appointments, that only 15 Democrats were the most. There wasn't a solitary qualified Republican to make the panel. That to me stretches all bounds of credibility. So let's recognize it. Let's bring it out into the sunlight. And the bigger thing is on the retention rate, something I didn't get to. That's what I think we're headed for a crisis. And it's open for crisis. You have what they call voter roll-off. And when people get to the judge's part, more than 30% of the people skip that part of the ballot. They just get there and say, I don't know what to do it, and they go on. And the way that the numbers have looked in Missouri over the last few years is that the numbers are around 60% for retaining. Just do the math. If you get voters out there that are saying, wow, this system is out of control, things are happening, then you even get 10% of those people checking out, you're going to have a whole bunch of good judges thrown out with maybe one that's not such a good judge. That to me is headed for crisis. So what I would like to see is us fix the appointment process at the beginning by at least having judges appointed in some way, even if it's one step removed, by elected officials that then the voters can take out their wrap up. You appointed that judge made a bad decision. You obviously don't have good judgment on judges. And you put it back into that. Again, let's focus on the research, let's focus on the facts, and less on anecdotes. And I think an honest assessment will come to the point that, yeah, there's room to update, hopefully lead the nation again with a new and improved Missouri.
What is the status of this plan? Is it simply hypothetical? Is it in the legislature? Are you looking at an initiative?
Well, the detailed status of it started in my home office basement over a period of months, and I circulated around to a number of folks in the state asking for comment, and then we put it up on a blog asking generally, hey, if anyone has any comments. And this is sort of the iterative process. I think what I'm going to try to do, and I hope others will join me if anyone's interested in looking at different plans and trying to come up with something. Hopefully the Missouri Bar will engage, perhaps even appoint an interim committee to look at possible alternatives. There is indeed a movement afoot to form a coalition. There's no coalition right now. It's 4 or 5 folks that are kind of putting their heads together on this. But what amazes me is I think we must be onto something, or at least at a sore spot, because the counter reaction from the forces trying to preserve the power has been amazing. So I think what you'll see soon in the legislature is at least introduce a new term. There will be legislation introduced. But there will be a coalition formed, I think, at some point. I'm trying to get other people together. Pat has hit me too hard last year. I don't know if I'm up for another year of fighting.
And Reggie, to answer your question, I think the only way any idea gets introduced in the legislature decides to do something with it, but it eventually has to go to the voters. This is an amendment to our Constitution. This is a very serious thing we're doing, very expensive, very cumbersome thing. This is not something that just somebody drops down and says it shall now be this. And Bill, no disrespect to your ideas, I think the reaction you're getting is much more the political attacks that occurred in the last way in which a justice to the Missouri Supreme Court was selected. And so I think there is a belief, I don't know if it's true, that this is part of a political strategy. You get small bits of off, then you think, oh, well, there needs to be reform because there's something wrong with it, and you get a little head of steam going up. I think it's kind of like what plaintiffs' lawyers do when you're trying a lawsuit. They somehow think that they ought to shift the burden to you to defend something when it's their burden to say why it ought to be different. And I think the system works. and I think if you talk to people who have actually been in the system, myself trying lawsuits, and again, I may disagree with some of these judges' decisions, but my recourse is not to vote them out of office. My recourse is to go back within the system and try to change the law. So this is a good democratic discussion, but it's not going to be a simple thing to change.
I know we've had a lot of discussions about this, but it seems to me like this whole thing sort of misses the mark, because if you've got a football team that's losing a lot of games, that's the evidence that maybe your coach isn't very good. And I've heard no evidence here that our judicial system in Missouri is broken in terms of quality of judges. Our firm and I personally have tried cases in at least 25 states, and I've always thought that our judicial system was the best judicial system in the country. And this plan's been in place for over 60 years, and there's no evidence that it's not working, because we have a great judicial system, and most people agree, and have agreed for all those 60 years we've had a great judicial system since the plan was put in place. In other words, there's no evidence that it's failed. And I can argue with you about the retention plan, because I think the retention plan proves the point that they all get high ratings, and that's because we've got a good judicial system. So I see no evidence it's broken, and I see no reason why we should start tinkering around with it, other than the sitting governor wants more his own party, or his own near-side 3-year-old chief of staff who got appointed in the Missouri Supreme Court. Well, he was one of the best Supreme Court justices we've ever had. And so that doesn't prove that it's broken. I mean, you can go through and pick out, well, this guy's this and this guy's that, and this is a good system. It turned out to be very, very good. I think it proves the point very well taken. So I just wonder, what facts do you have?
I wasn't here in the state at the time, but if someone comes to me on paper and says, by the way, 33-year-old with no judicial experience, was one of the best 3 qualified persons for the Supreme Court. Out of all the judges and lawyers in the state, that person was the top 3.
Maybe the judicial commission found something and they thought he would be what he turned out to be.
So as I look at that, I think to myself, well, that seems to me to be a little bit pushing it. So even if that one isn't pushing it, I've cited a number of facts that shows that politics play a factor in the whole process. One of which is, again, I'll go back to even 12 years of Democratic governors, 5 possible appointments, 50, out of 15 possible nominees, there wasn't one Republican in the entire state that was qualified. That doesn't make sense. And then this summer, you have only one Republican that's qualified, but 2 Democrats. I mean, that doesn't, there's at least a reasonable inference. And I can't prove it. I don't have a body. I can't prove it that politics, and they made that selection. They made that selection of Judge Berkowitz. And she may be the best thing out there, but at least gives the appearance that there was politics very much at play. The commission de facto made the choice of this governor, because it is a fact that the governor is not going to appoint somebody. They can't do that. And then going in reverse, what is wrong with the system? There is Professor Eckhart and John Hilton did a paper called The Consequences of Judicial Selection, and whether or not you agree with the conclusions, it's a great review of the status of Missouri law and where it came from during the Ashcroft bond years and the direction it's now going with the Holden Democrat appointees. And it conclusively, I think conclusively, at least says, look, this is where it was before. That's the case. It at least says that there is a influence depending upon which party appointed the person, in which direction the court goes, most of which is the death penalty. Now, I'm personally opposed to the death penalty, but if we want the death penalty out in Missouri, we need to do what New Jersey did and put it into our law and say it's out. But the fact of the matter is, it's part of our law. And this court has done more to create hurdles that are insurmountable. And I think that one case, State v. Glass, is one of the best examples of that, of finding excuses to overturn death penalty. Again, personally, I don't like the death penalty. I think it's wrong. But that doesn't mean we then force insurmountable hurdles in the state. Then we have government not by the people, but by the elected few. I encourage you to look at the Hilton and Nesbitt paper. I think it's a very good paper. And I do think, my personal opinion is, that this court over the last 2 to 3 years has interjected itself into many more political arenas. Just look at the dissents, the numerous dissents by Judge Lindahl over the last 2 years. I mean, it's gotten to where he's calling things out and he doesn't care. So to say that there's not an issue, I think it's just not right. And what I'm trying to do is say, look, let's do something better if we go through politics from the system. And people are going to say, no, the system is perfectly fine the way it is. Nothing I say, no facts I put up here, no amount of research and studies are going to help that out. The American Judicial Society says a bipartisan commission 3 times as likely to minimize politics. Many people say, it's just, who cares? Now, there's nothing I can say.
So one other thing, we'll take one more question tonight. Thank Bill and David for sitting here, and maybe they could hang around a few minutes afterwards. If some of you would like their email addresses or to carry on the conversation or to ask questions. But let's go ahead with one more.
Bill, is your plan, when you put out, is it going to be introduced by any House or Senate member? I mean, have you got someone?
A form of the plan will be introduced. Last session, there were 2 plans introduced. One was a commission that was called the Accountable Commission, which just changed the makeup of the commission. The other one was a federal body. What I tried to do over the summer is merge those 2 into something that I was hoping would be at least palatable to a number of people, but I see that some of the fruits of that have maybe been wasted. But again, I still, maybe it's unbridled enthusiasm. I'm hoping that by floating this plan out there, we can get some people to really come together and put together the best plan. We've looked at polls on it, and people don't like the current Missouri plan. They inherently say what Judge Longer said, that judges shouldn't be appointing their successors or their colleagues, and lawyers shouldn't be appointing their judges if they appear before. I think people react to that. So let's come together and get something that's really good instead of getting something that maybe you might not be so happy with.
I would be remiss, my partner, Charlie Harris, because I do want Bill and Charlie to talk to each other. I do want to identify Charlie so that those of you can talk to him. Because Charlie has the honor of being the president of the Missouri Bar this year, and so he is front and center with this, and I know he would be happy to answer any of your questions once we're done here with this. So I did want to introduce him and say that. And I want to thank you all. I do think that, and I want to thank Bill. I do want to thank him for what he's doing. I have no problem with a good-spirited, what he's made convinced that there is a political agenda here, which I think as lawyers we need to be alert to, no matter our political persuasion, to protect the judiciary as an independent branch of our government.
Thank you, everyone.